My daughter moved me into assisted living to steal my house, and when she came home to start packing my things, she found me sitting at my own kitchen table with a lawyer and a police officer waiting for her. I need you to understand something before I tell you the rest of this. I loved her. I still love her. The way you love someone who used to be someone else. The woman who showed up at that house in October was not my daughter. My daughter used to bring me soup when I had a cold. She used to call every Sunday. I don't know exactly when she stopped being that person, but by the time I figured it out, she had already started making plans. Her name is Renee. She's 38. Her husband is a man named Doug. And from the moment she brought him home 11 years ago, I felt something I couldn't name. Not dislike, more like a low hum in the back of my head that never quite went away. He had the handshake of a man who wanted you to think he was trustworthy. I should have paid more attention to that. My wife passed 4 years ago. Breast cancer. 18 months from diagnosis to the end, and I spent every one of those months at her side. After she was gone, the house felt like a museum. We had lived there 31 years. I repainted the kitchen the color she chose, kept her garden going, left her reading glasses on the nightstand for longer than I'm proud of. But it was still home. It was the only home I had left. Renee started coming around more often about 8 months after her mother died. Twice a month became once a week. Doug started joining her for Sunday dinners. They fixed the gutter over the garage. They helped me sort her mother's clothes for donation. I was grateful. I was a 67-year-old man rattling around a 4-bedroom house alone, and my daughter was paying attention to me again. I should have asked myself why. The conversation about Meadow Crest happened on a Tuesday in late January. Renee made the coffee herself, which she never does when we're at my house. She sat across from me with her hands folded and told me she'd been worried, that the neighborhood had changed, that the stairs were a liability, that her mother would have wanted me to be somewhere safe, with people my own age, activities, medical staff nearby. She had already visited Meadow Crest. She showed me the brochure on her phone. I said I wasn't interested. She said she understood, but would I just look at it? Just a tour. I said I'd think about it. She came back the following Sunday with Doug and a printed packet of information. She had highlighted the parts about the fitness center and the on-site physician. Doug talked about equity, about how much the house would be worth if I sold it now versus in 5 years, about whether I had really thought through my long-term care plan. The conversation lasted 2 hours. I was tired when they left. I told myself that was the worst of it. It wasn't. Over the next 6 weeks, variations of that same conversation happened 8 times, sometimes gentle, sometimes with a sharpness underneath that Renee would pull back before it fully surfaced. She started using the phrase, "at your age," the way people use a crowbar. My friend Lawrence from the hardware store called it ambient pressure. I called it my daughter, making me feel like a problem to be solved. In March, she brought a man named Orville to the house. He was an estate planning consultant, she said, just to make sure everything was in order. He had a navy tie and a briefcase that looked like it had never been in a courthouse. I offered them both coffee. They declined. Orville opened his briefcase and talked about peace of mind and simplifying assets, and how many families waited too long to have these conversations. He produced a document he called a trust consolidation agreement. Said it would protect me. Said Renee would act as trustee, but that I would remain the beneficial owner. My interests fully protected. I signed it at my own kitchen table. I want to sit with that for a moment, because it's the part I have the hardest time telling. I'm not a foolish man. I ran a small manufacturing business for 26 years. I have read more contracts than most people see in a lifetime, but I was tired in a way that had been building for 4 years, and she was my daughter. And Orville had an answer for every question I half-formed in my head, and I signed. I did not receive a copy. Orville said he'd have everything filed and would send the final packet by mail. Nothing came. I asked Renee about it twice. She said it was processing. I let it go. The suggestion that I try Meadowcrest for a short stay came in April. Just 60 days, she said, like a trial. If I hated it, I'd come home. She had already spoken to them about availability. She had already spoken to them, without asking me. Doug sat at the other end of my couch nodding along, and I remember thinking that this was the most time he had ever spent in a room with me voluntarily. I said I would think about it. 2 weeks later, I agreed. I don't fully understand why, even now. some combination of exhaustion and guilt, and the ancient, irrational fear of seeming difficult to my own child. I packed 2 bags. Renee drove me on a Saturday morning in May. The facility was clean, the staff was kind, and my room had a window that looked out at a parking lot. She hugged me at the door, told me she'd visit, told me to call if I needed anything. She did not visit. I called her cell phone 6 times in the first 2 weeks. She answered twice, briefly, with reasons she had to go. Doug called once to check in. He asked how I was settling in. I said I was fine. He said that was great. The call lasted 4 minutes. On the 18th day, a woman at the facility named Claudette helped me get onto the internet on the library computer. I wanted to look at property records. I don't know what made me do it that day. Maybe boredom, maybe instinct, maybe the memory of Orville and his briefcase and the document I had never received a copy of. I typed in my address. The property record for my house listed the owner as a trust. The trustee was Renee. The transfer date was March 14th, 5 days after I signed Orville's document. I stared at the screen for a long time. The library at Meadow Crest was empty except for a man doing a crossword near the window. The cursor blinked. My house, my address, her name. I printed the page. I folded it twice and put it in my shirt pocket. I went back to my room and sat on the edge of the bed and let myself have exactly 10 minutes of feeling the full weight of what my daughter had done. Then I started making a list. I am, at my core, a list maker. My wife used to tease me about it. Every problem I ever solved started the same way. Legal pad, blue pen. Items in order of priority. Number 1, get out of Meadow Crest. Number 2, do not let Renee know I was coming. Number 3, find a real estate attorney. Number 4, document everything. I called an old colleague named Bernard from the facility phone. We had done business together in the 90s. He was retired now, but he knew everyone in the county who mattered. I told him I needed the name of the best real estate attorney in the area, and I needed it that afternoon. He asked what was going on. I told him my daughter stole my house. He was quiet for a moment. Then he gave me a name, Harriet Voss. 15 years handling property disputes. He would call ahead. I called Harriet's office at 2 in the afternoon. The receptionist put me through in under a minute. I told her what I had found. She asked whether the transfer was completed before or after I moved into the facility. Before. She asked whether I had read the document in full before signing. I told her the honest truth, I had not. She was quiet for a moment. Then she said, "Come in tomorrow morning, 9 o'clock. Getting out of Meadow Crest required paperwork and a waiting period, neither of which I had patience for. I told the administrator I was choosing to end my voluntary stay. She reminded me there was a 60-day preferred notice. I told her I was 67 years old, and I was leaving voluntarily, and I would be happy to discuss the preferred notice in writing from my home address. She processed my checkout in 45 minutes. A cab driver named Curtis took me to Harriet Voss's office the following morning. I brought what I had. The printed property record, my original purchase documents from 1993, a copy of my mortgage payoff letter from 2008, my wife's death certificate, and every piece of documentation I could put together in the hours between getting out of Meadow Crest and sitting down at Harriet's conference table. She read everything without speaking. Her assistant brought coffee. I drank mine. She kept reading. When she looked up, she said, "The trust transfer is real. Your signature appears to be genuine. But the representation made to you about the document's purpose constitutes fraud if we can demonstrate you were misled about what you were signing." She took off her reading glasses. "Can you describe exactly what the consultant told you about this document?" I described every word of it. She wrote steadily the entire time. "We'll need to find Orville," she said. "That's not a licensed attorney. That's someone your daughter hired to execute this. There may be bar violations, there may not be, depending on how he's credentialed. But the misrepresentation angle is strong." She looked at me directly. "This will cost money, and it will cost you your relationship with your daughter, if there's any left to cost." I looked at the property record with my address and Renee's name. "Tell me your retainer." I came home on a Wednesday afternoon. The house key was still on my ring. I hadn't given it to anyone. The deadbolt turned like always. I pushed the door open and stood in the entry hall of the house where I had lived for 31 years, and it smelled right. Lemon wood polish and the faint mustard yellow smell of old pages from the books in the study. Mine. I walked through every room. The living room was unchanged. The kitchen. the hallway, my bedroom. But the study was different. My desk had been moved. The filing cabinet had a new padlock on it, which told me everything I needed to know about what Renee thought of the timeline. She had padlocked my own filing cabinet in my own house. The filing cabinet where I kept insurance documents, tax records, my will. I found a locksmith in the Yellow Pages. He arrived within the hour. He opened the cabinet without asking questions. Inside, my files were intact, undisturbed. She had locked it but hadn't gone through it yet. I photographed every folder before I touched anything. Harriet filed the motion to invalidate the trust transfer the following morning. We cited fraudulent misrepresentation, inadequate disclosure, and procedural irregularities. We had located Orville by then. His full name was Orville Pressman. He held a notary certification and a financial consultant credential from an organization that Harriet described as, and I'm quoting here, a certificate mill that will take anyone's $400. He was not an attorney. He had represented himself as an expert in estate planning, without disclosing that he had no legal training. When Harriet's paralegal contacted him, he asked if there was a settlement being offered. That answer told us everything about how confident he was. Renee called the house that Thursday night 8 days after I'd left Meadow Crest. I let it ring. She called again. Friday morning, I answered. Dad, she sounded surprised. Are you home? I am. A pause. When did you get out? I thought you were staying through June. I changed my mind. Another pause. Longer. Are you okay? Did something happen? I found the property record, Renee. Silence. The transfer date is March 14th, 5 days after Orville came to the house. I heard her breathe. I heard her decide something. When she spoke again, her voice had flattened into something I didn't recognize. That document protects you. It's an asset protection trust. Everything is still yours, Dad. Renee just manages it. Your name is on the title, as trustee. That's how trusts work. I asked you twice for a copy of what I signed. You told me it was processing. She didn't answer that. I have an attorney, I said. We've filed a motion. You'll be receiving paperwork, Dad. And now her voice changed again, went soft, went to the voice I remembered from when she was young and had done something she knew was wrong. Dad, please, we were trying to help. The house is too big for you. I need my house. I need my filing cabinet. I need you to understand that I am not confused. I am not declining, and I am not going to be managed out of my own home. I kept my voice level. That was the hardest part, not the anger. Anger I could have handled. The grief was the hard part. The attorney's name is Harriet Voss. Her number is on the paperwork. I hung up. Doug called 20 minutes later. I didn't answer. He called 3 more times that evening. I let all of them go. Renee hired a family law attorney named Broderick. He was aggressive in his filings and creative with his framing. His initial response argued that the trust was a legitimate estate planning instrument, that I had signed willingly, and that my sudden reversal reflected either undue outside influence or cognitive confusion. That last part is the one that made my hands shake when I read it. Not from fear, from recognition. Cognitive confusion, the same language she had started using in conversations a year ago. At your age, for your safety. I was starting to understand how long this had been planned. Harriet requested my medical records for the past 3 years. They showed no cognitive decline. My physician had documented my mental status at annual wellness visits, and the notes were unambiguous. Alert-oriented, good recall, intact executive function. She filed them immediately. My neighbor from across the street, a retired teacher named Loretta, who had known me and my wife for over 20 years, came by the second week I was home. She'd seen my lights on and wanted to make sure everything was all right. I told her what had happened. She sat down at my kitchen table and listened without interrupting, which is rarer than people realize. She said, I saw Renee at the house in March. She was there several times while you were still here, and then twice after you left for the facility. The second time she had a man with her I didn't recognize. They carried boxes out. Boxes. I hadn't gone through everything yet. I went back through the house more carefully that evening. The silver candlesticks my wife's parents had given us as a wedding gift. The coin collection in the study closet, 40 years of deliberate accumulation. A small landscape painting we'd bought in Vermont in 1989, nothing famous but ours. All of it gone. I added theft to the legal filing. Harriet located Orville Pressman for a formal deposition. He had retained a small practice attorney by then and arrived looking like a man who regretted a series of decisions. Under oath, the story came apart in the way stories do when they're built on convenience rather than truth. He acknowledged he had been hired by Renee. He acknowledged he had described the document as an asset protection trust for my benefit. He acknowledged he had not explained the trustee's legal authority or the actual title implications. When asked whether I had been given adequate time to review the document before signing, he paused for a long time before saying he couldn't recall the details of the timeline. Couldn't recall. The hearing was scheduled for a Tuesday in August. Judge Miriam Osei presided. She had a reputation for patience with witnesses and impatience with attorneys who wasted her time. Broderick opened with an argument I had expected. Willing signature, legitimate purpose, no evidence of coercion. He was polished and precise. Harriet opened with Orville Pressman's deposition transcript. She read the relevant section aloud and let it sit. I testified for 40 minutes. Harriet asked me to walk through the day Orville came to the house. I did, in detail. She asked what I had been told the document was. I told her. She asked whether I had received a copy. I said I had not, and that I had asked twice and been told it was processing. She asked what I understood my daughter's role to be under the document. I said I had been told she was a trustee to manage in my interest if I became unable to do so myself. She asked whether I had understood she would have title authority over my property immediately, effective from the date of signing. I said no. Broderick's cross-examination tried to establish that I was a sophisticated businessman who could not credibly claim ignorance of what I signed. I agreed that I had signed contracts before. I agreed that I was capable of reading legal documents. I told him that I had been given a document by a person my daughter presented as a professional estate planning consultant, told it was a routine protective measure, watched while it was scrolled through on a laptop screen, and asked to sign, and that my daughter, who was present during all of this, had not corrected a single misrepresentation made in that room. He moved on. Renee took the stand. She looked thin. She didn't look at me. Broderick led her through her version carefully, and she held it together until Harriet asked her, quietly, whether she had told me what Orville's actual credentials were before I signed. Renee said she had described him as a consultant who handled these kinds of arrangements. Harriet asked whether she had told me he was not an attorney. Renee said she hadn't used that specific language. Harriet asked whether she had told me the title to my property would transfer to the trust on the date of signing. Renee said the trust documentation covered those details. Harriet asked whether she had provided me with a copy of those details to review. Renee looked at the table. She said the copy had been mailed. I had checked my mail every day in those weeks. Nothing had come. Judge Osei listened through all of it without much visible reaction. Until the end, when Harriet presented Loretta's written statement about the boxes and the insurance records I had filed, showing the silver candlesticks and the coin collection and the painting. Then the judge's expression shifted slightly, not dramatically, just enough to notice. She called a brief recess. When she came back, she delivered her ruling without preamble. The trust transfer had been executed under conditions that met the legal standard for fraudulent misrepresentation. The trustee had failed to ensure adequate disclosure. The notary had failed to follow proper protocols for explaining the document's implications. The transfer was invalid. Title reverted to me, effective immediately. The stolen property was to be returned within 72 hours, or criminal theft charges would be referred to the county prosecutor. The gavel came down. I drove home in the afternoon, parked in the driveway, sat in the car for a minute looking at the pale siding, the garden that needed attention, the porch where my wife and I used to drink iced tea on summer evenings. Mine, still mine. The stolen items came back in cardboard boxes left on the porch. No note, no call. I unpacked them alone in the study, set the candlesticks back on the shelf where they belonged, put the coin collection back in the closet, hung the Vermont painting in its place on the wall, stood back and looked at it for a moment. Nothing dramatic, just a painting of a lake in autumn that I had paid $80 for, with a woman I loved, 35 years ago. The financial judgment came later. Renee and Doug were ordered to pay legal costs and damages. I was told they were contesting it, and that collection would take time. I didn't need the money. I needed the record. A court document that said, plainly, that that what they had done had a name. I changed my will the following month. Harriet referred me to an estate attorney named Beauchamp, careful and unhurried, who listened to the whole story before he said a word. The new will was explicit. The house, upon my death, would go to a housing nonprofit that supports elderly veterans in the county. My personal property to be distributed to 2 old friends and Loretta, who had been a witness when it mattered. Renee called once after the ruling. I let it go to voicemail. She said she hoped I understood that everything had been done out of love and concern. She said she hoped we could find a way forward. I didn't call back. In September, Bernard came over for dinner. I made the pot roast my wife used to make, which I had learned after she was gone, because I missed it more than I could stand. We ate at the kitchen table and talked about his grandchildren and the hardware store closing and a trip he was planning to the coast. Normal things. The kind of ordinary conversation that had felt unreachable 6 months ago. He asked, toward the end of the evening, how I was doing, really doing. I thought about it honestly. The house was mine. The legal fight was over. My daughter was someone I no longer recognized as the person I had raised. The grief of that was not a thing that would finish anytime soon. I'm all right, I told him. Most days I'm more than all right. He nodded. He knew enough not to push. After he left, I locked the front door with my own key and stood in the front hall and listened to the house settle around me. The tick of the old clock in the study. The refrigerator's hum. 31 years of living pressed into the walls and the floors and the smell of the place. There are things worth fighting for that don't feel like victory when you win them. They just feel like yours. And sometimes, when everything else falls away, that's enough.